Hello, everyone. My name is Boyd Allen. I'm your host for a series of podcasts presented by the Coalition for the Protection of PEI Lands, titled Landlines, Discussions about Land Use on Prince Edward Island. The Coalition for the Protection of PEI Lands acknowledges that Prince Edward Island is part of the unceded territory of the Mi'kmaq people. Furthermore, as non-Indigenous people today, we are inheritors of the treaties signed with the Mi'kmaq by our settler ancestors. At no time did these treaties grant rights of ownership to the settlers. To this day, therefore, in all our conversations, plans, and actions around the protection of PEI lands, the expression "our land" requires us to acknowledge that "our" must be understood as a shared responsibility, not ownership. We formed the Coalition for the Protection of PEI Lands in 2018 as a means to raise awareness about land issues in PEI, also to hold government to account on its responses to these issues. This series of podcasts is a result of consultations with our members and those who follow us on social media, which looked at ways we might try in the Coalition's continuing effort to share information and spark discussion on the issues around land use and abuse on the island, and why successive governments have appeared unwilling to be transparent about why these issues continue to happen. Today's episode is called IRAC, Transparency, Accountability, and Public Oversight. Our guest today is Mr. Petrie. In 1991, the population of PEI was 130,000. 71% of these people lived in rural areas. There were 2,400 farms from tip to tip. The decision to build the Confederation Bridge had not yet even been made. This was the year that the Public Utilities Commission, the Land Use Commission, and the Director of Residential Rental Property amalgamated to become the Island Regulatory and Appeals Commission, IRAC. Our population has grown to 180,000. The rural population has dwindled to be 36% of the total. There are less than 1,300 farms left on the island. PEI can by any measure no longer be considered an agrarian society. IRAC, through its administration of the Lands Protection Act and the Planning Act, played a significant role in this transformation. A lot of land has changed hands since 1991, and IRAC has had direct involvement in most critical land transactions which occurred during this time. What was IRAC's role during this time of change? Did it simply fulfill its mandate by facilitating the regulations within its purview, or did it also somehow shape public policy? Did its operating procedures accurately reflect the changes in island society? In its current form, does the Commission serve the purpose it was created to do? Today, in order to find answers to these and other questions, we are looking at IRAC through the lenses of transparency, accountability, and public oversight. Transparency has been defined as the principle of openly and readily providing information about activities, decisions, and processes to the public. Accountability involves the obligation of public institutions to explain their decision-making and to justify the conduct of their representatives. Public oversight refers to mechanisms in place to review and monitor public sector organizations and their activities, decisions, and processes. To be fair, the Island Regulatory and Appeals Commission, being an independent tribunal, is not technically part of government. Nonetheless, the scope and impact of its operations and its complex relationship with all levels of government should allow the public to hold it to the same standards of good and ethical governance. I am happy to welcome again, as our guest for today's episode, journalist, educator, and recent recipient of the Order of PEI, Mr. Petrie. So once again, Ian, we're going to peer into the complex world of the Island Regulatory and Appeals Commission and its administration of the Lands Protection Act and the Planning Act. True transparency in today's public arena is considered a bit of a unicorn, and IRAC's track record doesn't separate it from the pack. Essentially, there's no reason to expect transparency because there is no provision in the Governing Act to provide it. Did the Land Use Commission, the land administrative agency merged into IRAC in 1991, fare any better in terms of sharing information with the public?
It was a different animal for sure than IRAC, and I hope I'm not romanticizing too much about what the Land Use Commission was like, but what I always remembered and thought of at the time when I was covering disputes in various communities and so on was a group of islanders that the people that had concerns about they were trying to get adjudicated, they could relate to them. They could look at and see a farmer and a pharmacy owner and a teacher maybe and somebody else. Now, they might be connected to the government of the day, possibly, maybe not. But I think there was a sense of your neighbors kind of passing judgment on something that's going on. I remember that the Land Use Commission would travel if there was a dispute in a community somewhere, rather than having everybody come to town and sit in a stuffy room, in the middle of Charlottetown. They would go out to the community in the evening, when people could actually had their workday was over and they could come and participate in whatever discussion it might be. So as I say, I hope I'm not overly romanticizing this, but I remember an organization that just felt much closer to people, that people could relate to the mechanism or the thinking that they were doing to try to come to some kind of conclusion to do that.
Now, Ian, were they open meetings?
Oh, yeah. I mean, I'm not, I would be wrong to say that there was never a closed meeting, because I don't remember one. There may have been one. There may have been privacy issues perhaps back then that required that. But what I recall is a very kind of open system with people that people can relate to, and you could see in the questioning about how they were thinking and what they were looking at. The other thing was the secretary, John McClellan. The thing with John that I recall, and I'm going to quote from him later on in the podcast because I think he had very smart things to say. You had a sense with John that he shared many of the values that people had. He wasn't a kind of technical person or technician that was making sure that the legal rules are followed. You had a sense of someone who cared about land use, cared about land ownership and this sort of thing. And so, again, it gave you more confidence as the public that the deliberations that would go on, would be pushed in a direction that would look for some kind of reasonable or just answer. So it was a very kind of different animal. And I don't ever remember anybody saying, geez, I had no idea that they were thinking about this, or I don't know how they came to that conclusion. It did seem to be a much more open process.
Now, under the Land Protection Act, all land transactions involving land limits and non-residents must be investigated by the Commission, by IRAC. It then sends its recommendations on every application to the Executive Council, and the Executive Council makes the final decision. What these recommendations are and why they are made are currently protected under the blanket of cabinet confidentiality, as are the reasons cited for the decisions. Was this always the case?
It was more the LUC's relationship with the public as opposed to its relationship with cabinet, or I don't ever remember them saying we're not going to release anything publicly about, what we decided and why. I've been told, I guess 3 or 4 times over the years about this secrecy issue, which is very irritating. I think for everybody involved, it's irritating for the public. I think there are moments it's irritating for IRAC because they may have done a lot of good work, possibly, and no one knows that they did that or why they came to the conclusion that they did. The reason I have been told several times is that it prevents judicial reviews. That if the reasons for a decision to turn down a purchase is made public, then whoever wanted to make the purchase now has the basis to go to court and have a judicial review. Yeah. We did see that with the Brendel case. They came out with a thing that the purchase would not be allowed. And the first thing the Irvings did was go for a judicial review. Now, that judicial review has never happened because the Irvings haven't wanted to push ahead with it. So we have to for an instant just consider, do we want to see a series of judicial reviews by well-heeled developers who aren't getting what they want? I'm not saying that's a good enough reason not to have to be made public. My feeling more recently has been that whatever they decide should at least be shared with all MLAs. The public needs to have someone who's responsible to them in terms of an elected politician for them to have that kind of information. I think the information pipeline is way too tight when it's simply IRAC to cabinet. Cabinet announces whatever they're going to announce and no one knows why.
Well, what you have in effect is a daisy chain of deniability.
Yes.
Because nobody has to in any way explain what decisions were made and why they were made.
Mm-hmm.
Now, response provided by then CEO Scott McKenzie to questions asked at a legislative standing committee in 2021 may give more insight into IRAC's information sharing culture. Asked for details of an inquiry launched by IRAC on Buddhist land holdings in Kings County, which concluded in 2018, Mr. McKenzie stated, quotes, "I can neither confirm nor deny. We will not talk about any possible investigations that may or may not have happened." In this case, both the legislature and the public were effectively kept in the dark.
Mm-hmm.
If a legislative committee doesn't have the standing to expect answers from IRAC, then what does?
I mean, that's the question, isn't it? I believe, again, that this whole issue about this 2018 investigation into the Buddhist land holdings is a bit of a special case. I've written in a column, we talked about it in the last one, that we were talking about this, that it wasn't a wholehearted, robust investigation. And I think at some point, whether they were told or simply decided to shut the investigation down, he may not have had much to present to the committee or anything. And so he stick-handled his way saying, I won't say that there is an investigation or there isn't. On that particular investigation, we know we're going to get something more robust this time around. We've been promised that it's going to be made public. We're going to have a better feel for it. If McKenzie had said that about every investigation, I would say, yes, we have a huge problem. I do believe that particular investigation in 2018 is a somewhat special case. And I'm not saying that means it's okay for IRAC to deny or say that it isn't that.
Now, don't you think just in terms of information flow and a functioning process that it would have been much more effective to just tell the truth at that time?
Well,
or some version of it.
My guess would be, and I'm guessing on a lot of this, he didn't want to embarrass the Liberal government of the day by saying that they really weren't that interested in having a robust investigation. And so he said whatever he said to try to divert any more attention to this particular question.
Well, we'll carry this one step further.
Yes.
Where provincial ministers on their own don't necessarily get preferential treatment from the commission. When a report on this same inquiry was requested by Minister Stephen Myers in November of 2024, IRAC's senior communications officer responded by stating, quotes, "It had been forwarded to legal counsel," and that, quotes, "we will provide further correspondence in due course." Would IRAC being removed from education and early years and placed in a department such as housing, land, and communities provide a clearer change of responsibility and possibly more transparency?
I would think so, Boyd. I mean, I've always been confused as to why it's in the Department of Education, other than no one kind of wants to take ownership of IRAC, because IRAC is responsible for a heck of a lot of stuff. When you think of the major issues of the day, the cost of living and housing and so on, IRAC has its thumb in all of that. And so by having it in a department that has nothing to do with the work that it does, maybe shields it from having a minister that has to answer to what it's doing. So I'd have no difficulty if it were part of housing and land and so on and have a more direct link of who's responsible for it.
Because you'd have a chain of authority ingrained in the process. Now, the pathway of a typical application to purchase land made through the LPA from a non-resident or corporate applicant brings the concept of accountability onto the table. We end up knowing the specifics on a given parcel of land, the appropriate dates of the application, and the ultimate decision on the application's status. We don't know who made what decisions or for what reasons. Cabinet can point its finger at IRAC, and IRAC can shrug its institutional shoulder. Would bringing IRAC into the freedom of information and protection of privacy area of jurisdictions make it more accountable?
Of course. And I certainly have no difficulty with that. It's going to heap a whole lot more work on the privacy commissioner, and whether he or she at the moment has enough resources to handle all of that extra work. We have to remember, even within the Brindell case, she's involved because the report is being held up because the Irvings are arguing that the two islanders who are part of the ownership of Red Fox Acres, that their privacy will be affected if the report is released. And so she's trying to pass judgment on that. So in theory, I've been told if once she passes judgment on that and says, no, we don't think that it will invade their privacy, there's no reason for the report not to be released. So she's already involved on that particular file anyways in that. Yes. As a former journalist, I have no difficulty in having mechanisms for interested people and the media able to request information. I think that's important.
It seems as though the main reason for reluctance to be held accountable for these decisions is wrapped up in potential legal actions. Should IRAC not have been aware of these before suggesting the remedies which it did?
I need to ask you about the remedies that they suggested. What did they suggest?
Well, there was when the initial report went to the minister felt that he had been presented enough evidence that this transaction could not take place,
right,
that the land had to be resold. And that was with the full support at that time of IRAC's investigation.
Right.
So that was passed on to the minister, and he would not have acted if he didn't have full confidence that it was the correct course of action, right, that it was a remedy that was backed up every imaginable way. And then within a couple of months, that was reversed. Was this just missed by IRAC?
I did try to go through it the last time that we talked about this, so I'll have another quick go at this, that I believe what changed between IRAC telling the government, telling Minister Thompson that it was an illegal transaction. When you looked at the contract that had been set up, the relationship between Rebecca Irving and the two islanders that we just talked about, it didn't meet the test of beneficial ownership, that while you had two islanders who possibly allowed the amount of land to be accommodated, the benefits of the money that was made on this farm were going to again accumulate to the Irvings. And this has been the issue both times that the sales were turned down by IRAC and turned down by the government. The only thing that I can think of that changed, boy, here was the nature of the contract, that the Irvings relented and said, okay, the benefits will go to these two islanders rather than into the Irving group. We have to wait to see if that's in fact what they discovered and what they recommended to government. There was no reason for IRAC to change its point of view. It had spent months investigating this and turning it down. Why on earth would you 2 months later say, no, we're okay with it now? There was mention by Minister Thompson that it had to do with a global lease.
Yes.
I've been told that that's not the case, that wasn't the reason really that they finally agreed to that. There may be a global lease that they've organized, as many large corporate farms do have global leases. So I'm not saying there isn't a global lease, but in terms of the reason why all of a sudden they said they're in compliance as opposed to non-compliance, I think is something different.
But what it appears from the outside looking in is that IRAC was simply outmaneuvered by the Irvings, ultimately.
Yeah, I mean, listen, we were all outmaneuvered. Only good news I can give you is that when you go back to the very beginning of this, the Irving family thought they could simply incorporate this 2,200 acres into all of their other land holdings and no one would pay any attention. There was a hell of a stink, and people fought against it and so on. If what I'm arguing is true, that these two islanders, as opposed to the Irvings, in fact, are the beneficiaries of whatever happens on Brendell or on Red Fox Acres now, then the Irvings have not been able to simply accommodate all of this land into their holdings. It's something different than that. I'm not saying it's anything that those of us that care about all of this stuff, we would rather see a different ending to all of this. We would rather have the Irvings say, okay, we tried, we failed. Let's turn this land into public ownership and let's lease it to other farmers and let's start anew, because there's so much frustration with this particular issue and so much confusion over actually what happened. And people can read into it really whatever they want. And I'm giving you my take on it, and I could be totally wrong, but I think none of us have been well served by this particular issue. On the other hand, it has highlighted concerns about when should IRAC get involved in passing judgment on this, because the other thing we have to remember with these two islanders and Rebecca Irving, as islanders, it didn't automatically go in front of IRAC to be judged. And when Minister Thompson recognized that, he brought an amendment in to say any corporate ownership, no matter who the owners are, whether they're all islanders or non-islanders, IRAC has to get a kick at the can. I think the other thing we have to try to remember, even in the amendments that have come up, it's not necessarily that the amendments will lead to the decision that all of us would like. It's that the transaction will get in front of IRAC, that IRAC will at least have a chance to look at it, investigate, and pass judgment on it. Because this is how, particularly with the Brendell, it kept slipping through that, right, with the corporate ownership change, and then this particular way where you had three islanders, in fact, owning Red Fox Acres, didn't automatically go in front of IRAC. So if there's been anything useful that's come out of this whole Brendell thing, at least there have been a few things that have been tightened up. Are there other things that need to be tightened up? Of course there are. But I'm just saying there are at least some of these things that have been kind of lurking around the edges, at least got the spotlight on them and said, we can't allow that to happen again.
Now, IRAC's institutional culture has never considered public oversight as being part of it. Taking steps to further limit those eligible to launch or be considered interveners in their appeal process is an indication of this. In 2023, its ruling overturning the province's rejection of a proposed subdivision in the rural municipality of West River, it stated, in face of local residents' concern about this outcome and their lack of input to it, IRAC stated, quotes, "Community consultation and or public input is not part of the appeal process." Its disdain for municipalities' input into land planning decisions has been made clear in many instances. Did the Island Land Use Commission, as you recall it, have a different approach to public oversight?
My remembrance is that the public input was the bread and butter of what they were interested in. They wanted to know what neighbors thought of a pig barn going up, or I remember there was one where a farmer was spreading shellfish waste and wasn't plowing it in quickly enough, and so the neighbors had wanted some kind of intervention by the province on environmental grounds, that they had to do that. And, there were dozens of small things like that, but they viewed their role, the most important thing that they did was finding out what the neighbors thought, what the public thought. I did mention the last time we were talking about these things that, to me, the evolution of this was that once lawyers started coming to the Land Use Commission hearings, it changed their nature a bit. Now we're talking about technicalities and the law and so on. I'm not saying that lawyers aren't important and the law is not important. It is, but it just changed the nature of the thing. And I suspect this was one of the reasons that IRAC was created, because now it's become more of a technical thing in terms of what the legislation says and what the regulations are and who's responsible for this and that. And I think for that reason, it's kind of taken it out of that sense that the general public can follow what's going on and has a feel for, what really matters. I don't know in the kind of litigious times that we live in, whether how the LUC operated would survive in the kind of world that we're living in. But I'm not sure that the technical approach and the lawyers at every corner of the room is necessarily serving the public well either.
Well, that kind of leads me into the next question, too, because with IRAC answerable to the Executive Council and not obligated by its foundational legislation to include public oversight in its operational model in any manner, how can a legitimate niche be carved out for it? What do we need to happen in order to bring some element of public oversight back into the process?
That's the $64,000 question. I agree with you. And I would certainly argue that it's critical. The thing with appeal bodies and so on, if the public doesn't know how it's working, how decisions were made, if people lose confidence in the system, and I think to some extent there have been enough examples. The West River, to me, is the most egregious under the Planning Act in terms of IRAC going further than it certainly appears that they should have gone. And, having bylaws that had been passed and it's just they hadn't been approved yet, they were ready to go. Other than, having interveners, having some kind of public representative on these things. But again, you're asking an intervener to represent a whole lot of different voices out there who may, feel differently about it.
But as it stands now, there isn't anybody representing it.
That's right.
I mean, and that's
not good.
When we're looking at a situation from tip to tip in terms of development and development pressures, in this milieu, the environment is not being represented by anybody or any entity.
Right.
It should be, one would think, the provincial government. And the provincial government has not shown an appetite in terms of appealing an IRAC decision.
Listen, if I were publisher of a newspaper on PEI, I would assign a reporter to do nothing but follow IRAC investigations and to write 2-3 columns a day about what the investigation's about, why it matters, what IRAC is hearing. The public needs to be informed about what's going on with these things. And if the public is informed, then ideally, IRAC could make some kind of mechanism for public opinions to be heard so that it becomes part of their record as they go to make decisions. As I say, this is what made the LUC, in my mind, function so well, is that the interest or what the public thought was their bread and butter. That's what they wanted to hear.
But you had elements of consensus as part of the process, which it may be in place in the IRAC model. We just can't see it.
Right. Yes. And as I said, when you have a system that feeds on secrecy and people not knowing why decisions are being made, people can make up whatever they want in terms of this is why it happened,
Now, another element may have become part of the Commission's culture during its 34 years of operation. This is the concept of mission creep. Mission creep can be described as the expansion of an agency's original objectives, scope, or goals beyond what was initially intended or approved. IRAC's 2023 granting of an appeal for a developer in the West River municipality comes up again. In the province's original denial of this application, They cited loss of farmland and protection of shore frontage as reasons for so doing. In their ruling to overturn this denial, the Commission stated, quotes, concerns over removing farmland and affecting viewscapes were not sufficient reasons to reject a subdivision. Was IRAC ever tasked to adjudicate the value of a stated government policy?
It's quite possible they were. I don't remember a time where they were asked to do that. And as I said, this West River story, in my mind, is one of the worst examples of how the system worked. I don't think there's any question. And I think
more.
in one of our public hearings, there was the chair of the West River. She made a really good case about the effort that they had made, to have the right thing happen here. Far be it from me to say that IRAC has passed judgment on government policy or hasn't.
It was revealed in the 2021 Legislative Standing Committee meeting that orders related to violations of the LPA have not been published on IRAC's website since 2014. Then IRAC CEO Scott McKenzie explained this change by saying, quotes, fines and penalties for these infractions acted as a disincentive for corporations to report errors. He continued with, we started acting more cooperatively with the corporations and businesses and persons in these circumstances. McKenzie concluded by saying that these changes had not been discussed with the then minister overseeing IRAC, Doug Curry. How can the enforcement of a standing LPA regulation be stopped without at least some form of oversight from cabinet?
I have no idea. I think, Scott McKenzie was there through a lot of difficult things that happened. And from what I hear from others, that he did a pretty fair job. In this particular case, I think, and this is where as we talked earlier, because there doesn't seem to be any kind of link between IRAC and a minister who is in charge of what IRAC does, this is the kind of thing that can happen. IRAC becomes isolated and kind of becomes its own decision maker in terms of what it's doing. And that's not a good thing either.
Now that leads me to the next question. Has this approach become some kind of a working policy within IRAC? That they are, to all intents and purposes, cut adrift by the process as it looks or as it appears right now, that they make decisions on the fly that they feel appropriate to the situation, or there is a method of dealing with certain elements of development in a manner that expedites it. If that becomes the policy, then that becomes the policy.
That shouldn't happen. I quite agree with you. And I think when you get an organization like IRAC, which is responsible for so many things, the price of fuel and rent and so on and so on and so on, and obviously it's a wonderful buffer between politicians and their constituents in terms of decisions that get made, and the politicians don't have to take any responsibility for it. I do worry, as I said earlier, that in this litigious times that we live in, that we need to find some kind of mechanism that's fair to all involved, that isn't linked up with too many lawyers, because obviously the people that have money are going to win that game every time. And we've seen the effort by Tim Banks in terms of not wanting to have Island Nature Trust be able to stick their thumb in stick in the spokes of development and so on. These are all important issues, and it's getting back to a sense that the public has the opportunity to find out what's really going on in these cases, and that they can relate to how these decisions are made. This has to get better. I agree.
Another example, in April of 23, IRAC issued an order on an appeal launched by the PEI Energy Corporation over the rural municipality of Eastern Kings' 2020 decision to not allow the expansion of a wind farm within its jurisdiction. In its ruling, IRAC sided with the PEI Energy Corporation. Further to this, the order chose to remind the province that, quotes, it always remains open to the Lieutenant Governor and Council to make regulations under the Renewable Energy Act to regulate the development of this renewable energy generation facility and others." End of quotes. This would essentially remove municipalities from this type of discussion. The province quickly applied IRAC's suggestion. Now, the question is, does becoming a consultant to the provincial government in this manner not erode IRAC's position as an independent body and perhaps taint the process it was created to oversee?
I mean, this is another good example of, on the one hand and on the other hand. I mean, clearly the provincial government, for good reasons, wants to see wind energy being developed on PEI. And I think most people, this is a one energy resource we have, and we're trying to do it. And there are certain red spots around the province that have the wind resource that can accommodate these kinds of huge turbines, and that happens to be one. I can remember at the time that the complaint was, well, these are just American visitors that don't want to have, it's like Donald Trump and his golf course in Scotland. He's upset about wind turbines being in their views. I think it was a little bit more than that. I think there were migratory bird issues, and this always feels clumsy. It always feels like somebody's lumbering towards getting to what they want without a really good explanation. I think Minister Myers at the time played his normal bully put role in terms of pushing this through. I think IRAC probably said the right thing to government, that don't make us the bad guy here in terms of, supporting development of wind energy. Put it into your legislation. Now, does that take away community council's role in determining whether these things should be built? There needs to be, part of that mechanism needs to include, the position of community councils.
Because even
is renewable energy something that's, again, a sort of separate case from other land use issues?
But even in the wording of IRAC's ruling on this, they used the phrase of the council being well-meaning, but. So that, once again, that coupled with this recommendation or suggestion that the regulations get cleaned up in the Act, to me, is beyond what their role was to be in this circumstance. Their role in this circumstance was to adjudicate an appeal that was brought forward on a municipality's decision on a development. It was not to craft legislation to ensure that the same thing didn't happen again.
Right. I suppose from IRAC's point of view, having agreed that this project should go ahead, in essence, they were choosing the province over the municipal council, over the local council. Whether that's the right answer or not, that I don't want to pass judgment on that. And I suppose what they were saying is, if we're being forced to do that, it would be better if there was legislation saying that the Department of Energy has this kind of authority to do this. Again, we all like to think of that decisions are always best made at the most local level that you can, the people that are really directly affected by whatever the decision might be in terms of an apartment building or a wind turbine. There are going to be times when larger issues are at play. We have to remember with the wind turbines, a lot of the cost involved is the lines that have to be erected in order to take the wind energy from the turbines into the system. And if you had to go now move all of these turbines into some completely different place, you're adding huge costs because you'd have to add more lines that in order to get the power into the grid. And I suppose I'm showing my prejudice towards thinking that wind energy is something that we need to develop, and we need to go to those areas, Point Prim and others that haven't been developed yet, and see if there are ways that we can get them involved. But
now my point in this is that if you even take the rights and wrongs out of it, take what is the appropriate thing to do according to your own wishes, what I'm saying is that the process itself is flawed in that independent tribunal looks at this situation, makes a value judgment which impacts their ruling. And in so doing, it creates a precedent moving forward. So the municipality's role, be they right, be they wrong, has been taken off the board.
Yep.
And I think that in this instance, that is the issue that I'm concerned about.
Yep. No, and I completely understand what you're saying. It's similar to the case that we talked about in the former podcast about an apartment building that the Charlottetown City Council said no to. IRAC looked at it and said yes. There's no reason that listening to the neighbors, isn't a good enough reason not to allow the project to go ahead. So it allowed the appeal to go in favor of the developer. There are two things here. One is the initial or the final judgment that IRAC makes that may be right or wrong depending on where you sit on various issues. The other thing is, should they have the mechanism to do that, and are there enough ways, for them to get public input? That's the thing that I find most intriguing in this. In this particular case, where you're dealing with a rural area with cottages and so on, the locals may say, we don't want that here,
But it's interesting, in the cases that we've been looking at today, you have two significant cases, one Eastern Kings, one West River. IRAC states in its ruling that development of subdivision is more for the greater good than the agricultural land that is being involved in the development area. Sure. It is also more for the public good to discount the shore frontage issue as a reason not to create a subdivision. So that is a value that is attached to this ruling. Yep. And then you go east and they say wind energy is good. Wind energy requires amendments in the existing regulations in order that the resistance from municipalities is taken out of the mix. To me, it is not indicative of a tribunal.
It's mission creep, as you were saying. They put themselves in a position of making things happen when, in essence, they're there to judge what kind of things, where you have competing interests in a thing, which side it has the most reasonable thing and meets the law and all of that sort of thing. As I said, the West River thing I've always found very troubling, right from the get-go. And I'd love to have a better understanding of why they would go in that direction, because, they weren't saying that this developer couldn't ever do this ever. I mean, what they were looking at was a particular thing. And given the role and the effort that the community made to try to get their point of view across, that they didn't want to see this. And given that, certainly, again, from my point of view, I think protecting farmland is an important thing to do. Protecting viewscapes and so on is important.
But ultimately constitutes the greater good should not be the role of IRAC.
Right.
A coalition founding member, Marie Burge, on behalf of the coalition, wrote the following in a 2021 paper. The Coalition for the Protection of PEI Lands believes that it is time to relieve IRAC of its responsibilities relating to the Lands Protection Act. What is needed is a new commission or agency, part of government, but free from political or corporate interference, and with full authority to carry out proactive investigations and prescribe remedies. It should be attached to the appropriate government department with clear lines of accountability to the government and to the public. Is it time to consider breaking the land component of IRAC's responsibility out to another agency?
It's interesting. If you go back to 1971, when there was the initial look at land ownership and land use in the province, at that point, the group that looked at it said, we don't have to think too much about land ownership. It's land use that's the most important thing that we should consider. There's a wonderful paper called the Prince Edward Island Lands Protection Act, The Art of the Possible by Margaret McCallum. She was a UNB professor. She writes a fascinating story about the history of land use commissions and IRAC and the lands protect. She's particularly focused on the Lands Protection Act, and she talks about how court decisions and politicians over time change their views over what the politicians should be considering and what they shouldn't be. I'm not in any way opposed to the Lands Protection Act being handled separately. I mean, we're still dealing with trying to find this group of people that aren't linked up with anybody else and are, completely go home in the evening and lock themselves in a closet and never talk to anybody, and so can be honest adjudicators of all of this. We do need to find ways of being able to bring more confidence, I guess, to the Lands Protection Act. The challenge always with this thing is we see decisions, here and there that we don't like. So we think, it's IRAC that's the problem, and we need to change it. They could be making a dozen other decisions that were pretty good, So if there ever isn't a study or an effort to try to look at what IRAC does, and the decision is made, and Marie knows I have enormous respect for her position on virtually everything, and I'm not sure that separating it in itself is necessarily going to solve the problem. I think we have to think through other mechanisms in terms of making sure that the public has a way into it. We have to somehow lessen the importance of lawyers in all of this, because as long as it becomes a sort of technical legal thing, it's going to alienate 90% of islanders. They won't necessarily appreciate what's going on. We need to bring the spirit, I guess, of the Land Use Commission back into play somehow.
Now, are there any models that jump out at you that look like a template?
I've thought about this, certainly getting ready for these podcasts. I've tried to think of, because I knew you were going to ask that question, is there something out there that we could look at? I know when the Lands Protection Act was created in 1982, they looked at land ownership rules in Saskatchewan. It was the first province in Canada to try to control who could own land. It might be interesting to revisit there and see how they're making out. From what I read in agricultural newspapers from Saskatchewan, they're not doing very well at all. There's deep concern that there's offshore money and Chinese money and Iranian money and U.S. people and corporate money, and, that the average farmer in Saskatchewan can't buy a land anymore, can't afford to do it. All of the concerns that we hear here are being repeated out there. So is there a model somewhere? I don't know.
Now, do you, just to give you the opportunity once again, do you have any further thoughts on where IRAC finds itself in 2025?
One of the things I've tried to think about in getting ready for this, did IRAC in a sort of power-hungry way kind of grab onto things to make itself more important? Or do politicians kind of take things, irritants and the price of gas and so on, and throw it at IRAC because they didn't want to take responsibility for it? I suspect there's a little bit of both going on. I think it does play a useful role for politicians in terms of being responsible. There's a whole layer of people at IRAC that were responsible for energy prices that are brilliant at what they do. They spent years following the wholesale price of gas in the New York Harbor and the Brent crude price in Norway, and, trying to make sense of why the price of regular here on PEI for a long time was 10 cents a liter higher than anywhere else. And it isn't anymore because they regulate it, because they pay attention. And when oil companies want to raise the price, they have to prove why. They have to pass in a document and say, this is why we need more money for it. So I'm very much in favor of having those kinds of regulations. I know not everybody likes it. Everybody thinks if there was competition, the price would go down, and what you'd end up with is competitive pricing in Charlottetown, and the price would go through the roof in Surrey. So I think IRAC plays a useful role. This Lands Protection Act is really tough. It does require judgment. It does require trying to meet the test of other lawyers for large developers and so on who are tasked with finding ways around the act and finding ways for the people that they're representing that will get what they want, So do we need a more hard-nosed group that will be in charge of that? Possibly. I'm much like you. I mean, I think if the public had a better understanding of why IRAC makes the decisions that they do, and the information that you've highlighted in the last 45 minutes, where we do have public information about what they said and why they said and so on, tells us that things aren't working in the way that a lot of people would like to see them work, And will that mean that IRAC will behave a little differently in the future? Maybe. I do think it's time for how IRAC operates. We need to have a closer look at it, somehow, whether it's a Royal Commission or whatever it might be. Very important to people's lives. I think they probably do a better job than a lot of people think, but because so much of it is secret, we can't gain that confidence that they do know what they're talking about. And the commissioners themselves are, for most islanders, completely unknown. And to me, that was a big difference with the Land Use Commission. These were people that people recognized and sort of knew where they were coming from, because IRAC is a different kind of organization than that. And so that doesn't help with their credibility. They do get to adjudicate and get a resolution to things. Is it what the public, it's not necessarily what the public wants, because sometimes decisions are not what the public wants, but we need to have a better understanding, a better feel for why decisions are being made the way they are.
Now, I know you've been writing about land issues on PEI for over 40 years, and IRAC has had a part to play in most of these issues you covered. I can't think of anyone more qualified to help put it in perspective for us. Thank you, Ian.
Okay.
Now, we've looked at IRAC's role in land administration on the island for the last couple of episodes. We've touched on its origins and structure. We examined how it approaches LPA investigations and Planning Act appeals. We've reviewed its standard operating procedures and underlying institutional culture. Perhaps instead of finding answers to our questions, we just uncovered more.
And just while you're there, Boyd, I wanted to just have a short comment here from John McClellan, who was the executive director of the Land Use Commission. And he said this in 1987, okay, and it's very short, and it fits with what you're saying. Quote, "There has never been a consensus within our society on the purpose of the Lands Protection Act and how it should operate. The public interest that the Act is presumably designed to protect has never been adequately defined." So I think we're still there.
How does it decide? We'll go back into IRAC world. How does a tribunal tasked to administer a set of regulations choose to pick which of these regulations warrants its attention? How does it decide who warrants intervener status to its own appeal proceedings? Why have IRAC's political paymasters not felt the need over the last 34 years to restructure the act which governs it, to insert elements assuring transparency, accountability, and public oversight into its operational model? I mean, perhaps this means breaking the LPA and Planning Act administration into a standalone agency. Until a significant change takes place, it's going to be tough to solve land use problems that are generations deep, let alone face any challenges popping up on the horizon. Thanks again to journalist and educator Ian Petrie for showing his depth of knowledge with us today. I know we just scratched the surface. I'd also like to thank those who made the time to listen to this episode. If you find something of interest in it, please share it and subscribe to our YouTube channel. We also welcome your comments on this or previous episodes.